Yeah, that's what I was wondering. What were you testing before? Were you testing?
No,
So you didn't have any alcohol monitoring?
no.
We're starting with a courtroom exchange that immediately feels unpredictable. Mr. Wainwright is asked about a forensic psychiatry evaluation, but the conversation takes an unexpected turn before the judge orders another discussion and adjourns. What happens next reveals how carefully this court handles difficult defendants. Subscribe for more dramatic breakdowns.
Assistant Public Defender Dr. Lebo for Mr. Wainwright.
Mr. Wainwright, can you state your name, please?
Oh, how are you?
I'm great.
Oh,
What's your
really?
name?
Well, if you say so. Actually, I'll say Stephon Dallas Winner. Let's start with that.
Okay, that's Mr. Wainwright.
Yeah.
What are you doing?
Let's go where the defendant was declined competence for forensic psychiatry. Defense counsel at that time intended to seek an independent evaluation. And
Right.
no longer want to do that, stipulate to the finding of competency.
And Your Honor, that was my intention. However, seeing Mr. Wainwright's indications today, I believe we may need to revisit that. So I'd like Trustee Ingram to go speak to him again.
Your son cannot ball, Alec. Put that nigga in the sewer.
Hold on, Mr. Wainwright. You want to do what?
I'd like Ingram to go speak to him again, Your Honor.
You want to speak to him again?
Yes, please.
All right.
I'll just hire someone. Comes to it.
Okay, somebody's going to come in. Mr. Wainwright, somebody's going to come down and talk to you again. Make sure everybody's headed in the right direction. So I'm going to adjourn this out to June 18th, 2026, 9 a.m. Thank you.
Thank you, Your Honor.
Court calls the case. People versus Kevin Shivari Lowry. Turner Bay Lowry, actually, I think it is.
Your Honor, Amy Lucas requesting permission to practice.
And that. Fine.
Your Honor, Amy Lucas requesting permission to practice pursuant to Michigan Court Rules 8.120 under the supervision of a public defender, Jay Phelps.
Really?
Yes.
You have Bellinger?
I do.
How'd you draw that short straw?
I think I got lucky.
Really?
I really do.
That's beautiful. All warm and fuzzy inside now. I don't think I've asked you on the record. Where are you in school?
I go to Wayne State.
Wayne?
Mhm.
Okay. All right. Where'd you go to undergrad?
Kalamazoo College.
All right. Where are you from?
Plymouth, Michigan.
Plymouth.
Yep.
Okay. So you're a Michigander, just haven't left.
Nope.
All right. It's like some of the rest of them. Permission to practice is granted.
Your Honor, we're
Hold on. Sir, can you state your name, please?
Kevin Williams, Shinavar Lowry Jr.
Thank you, sir. Go ahead.
Your Honor, we're seeking to adjourn the matter out a couple weeks. We just received the complete report yesterday, and we haven't had an opportunity to go over it with the client.
Okay. That objection, probable cause conference, June 18, 2026, 9 a.m. bond contingent. Thank you. Thank you, sir. Court calls the case People versus Chance Baylor.
And on behalf of people, Your Honor.
Michael Gaddy's public defender on behalf of Mr. who's making his way to the podium, Judge.
Your name, sir?
Chance Baylor.
Thank you.
Your Honor, we're asking for an exam in this matter.
Discovery is complete.
The best of my knowledge, Judge.
People have their witnesses available to 16th. Preliminary examination will be set in person. June 16th, 2026, 9 a.m. before me. Okay. Bond will continue. All right, thank you.
Well,
Court does call the case. David.
On behalf
Thank you.
This is Public Defender Zach Binney with on behalf of Mr. David Proker. Sir, please state your name for the record.
Aaron Michael Davis.
Thank you.
Yes, sir.
Your Honor, we're seeking an adjournment to review discovery and then would ask to be heard on bond.
Okay.
Um,
PCC will be adjourned to June 18th, 2026, 9 a.m. As to bond.
Your Honor, Mr. Davis, him and I spoke for about an hour on Monday. He stated to me that he had been doing well, but then in December, he stopped taking his meds, stopped going to his psychiatrist, stopped following the 12 steps, going to AA meetings, and ultimately relapsed in February. He does have another case out of Oakland County where he has been sentenced to a year in custody. In that case, he does have a release to a locked-door inpatient facility in Flint, so we would be asking for a release to treatment in this case as well.
Response.
So the next case out of open is a domestic violence case with a different victim that occurred 2 days after this case. If the court was inclined to send him to treatment, I'll be asking for a tether given the seriousness of these charges and the fact that he is currently under sentence for another domestic violence case.
Anything additional?
Your Honor, Mr. Davis has indicated to me that he would accept a tether.
Well, right, but you're asking for his release. I have some concerns about his release. What does he have something in place regarding his medication protocol?
I'm back on medication. I'm back on medication too, Your Honor. I'm back on psych medications. I'm back on my medications and stuff too.
Okay, but how's that? I mean, how's that happening? I mean,
I seen CMH in the jail. I seen CMH in the jail. And I got back on medication about 5 to 6 days ago. So I'm back getting more stabilized. Yes, Your Honor.
okay, so let me ask you this.
Yes, sir.
If you were released, what things do you have in place to make sure that you're going to stay on that course?
I'm going to go back to my recovery therapist. My mom just talked to my mom's in the courtroom back there. She just talked to my recovery therapist yesterday at New Path. I've been seeing them. I'm going back to my psych, Robert Hughes at GHS, which used to be called CMH in Flint. Back to my social worker, David. Back to working the 12 steps. I've been back doing it on my own myself already. After my 6th time, I've been doing the 12 steps in the last 3.5 years. I relapsed for 1 month and a half. And I'm basically losing my company and losing my home, losing all my like everything I've worked hard for, and I've seen where I went wrong. And I would just please give me a chance to get back into treatment and get my life back together, please.
Okay. Would the people still have any strong objections if he's released with some assurance that he's going to continue on that path? Because it seems.
Sure, I think maybe a tether would be good, and then in order from the court potentially to have him continue his communications with CMA to follow all recommendations with them and mental health professionals that he is in contact with.
Okay, so here's what I'll order. At this point, I just follow me. I'll deny the bond, prepare an order, counsel, indicating that, but that he would have to be on a GPS tether. And I would agree with the people that he would have to follow the orders and recommendations of CMH here in Washtenaw, as well as the ones in, what is it, Genesee County?
Yeah, yep. Yes, sir.
All right. So if all of that's contained, then I'll sign off releasing him on a PR with those conditions.
Yes, sir.
All right.
Sir.
Okay.
Your Honor.
Thank you.
I'll get that order in today, Your Honor.
Thank you. Was Bellinger yelling at you?
No.
No, because I can have Alan take him out.
No.
Okay. All right. Court calls the case. People versus Deontay Jordan.
At this point, the judge is weighing more than a simple request for release. The defendant describes relapse, restarting medication, returning to recovery support, and losing stability, while another domestic violence case raises serious concerns. The judge requires strict supervision, mental health compliance, and GPS monitoring before allowing release. Would you agree?
Good morning, Your Honor.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Jordan, who appears via Zoom.
Mr. Jordan, can you state your name, please?
Deontay Jordan.
Thank you.
Your Honor, I believe the court signed the order appointing me as counsel. We're requesting a brief adjournment. I don't have the discovery.
Matter will be adjourned June 18th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case People versus Kimberly Douglas. Back. That's the fastest I've ever seen you guys move.
Your Honor, we are seeking to set the matter for examination. Discovery has been complete to the best of our knowledge.
All right. People have their witnesses available the 16th. Preliminary examination will be set June 16th, 2026, 9 a.m. before Judge Moore. Thank you. Bond will continue.
Your Honor.
Well, they don't leave. That's fine. You have been told once I. Okay. Court does call the case People versus Malachi Beverly.
Your Honor.
Hey, Bachi.
Assistant Public Defender Jay Bellinger on behalf of Mr. Beverly, who should be in appearance via Zoom or in person. No.
There we go.
What's your name?
Can you hear me? Malachi Beverly.
All right, that's it.
Thank you, Your Honor. We are seeking a brief adjournment on this matter. I am working with Ms. Zendo to see if we can come up with a resolution.
Why not? Everybody else had. Just Jesus. All right. Record to reflect you had a bench conference in this case. I will adjourn the probable cause hearing in this case to June 25th, 2026, 9 a.m. His bond will continue. However, I will add, understanding there may be no objection, it probably should have been in place in the first place, a testing requirement that the defendant is to report to community corrections for placement on a SoberLink testing device 3 times a day, and I will be signing that order. You understand that, sir?
Yes, sir. Yes, Your Honor.
You need to get over it. You need to get over to community corrections within the next 24 hours, okay?
Okay. Thank you.
All right, thank you.
Thank you, Your Honor. And
welcome.
Mr. Beverly, just give me a call if you have any questions.
Okay, I can call the same number.
Yep.
Okay.
Why are you changing? Tell me, I'm gonna take it. The court does call the case versus Maisha Gaines.
Michael Gaddy, Assistant Public Defender for Ms. Gaines, Your Honor. State your name, Ms. Gaines.
Maisha Gaines.
Thank you, man. What are we doing?
Your Honor, we're asking the, I do have a green sheet. My apologies.
You're asking for an adjournment.
Yes, Your Honor. We're seeing if we can't negotiate something globally. If I could be heard on bond.
18th, 2026, 9/8. Yes, that's fine.
Yes, Your Honor. Ms. Gaines was placed in custody a couple weeks ago. Ms. Gaines from our office has had a chance to speak with her. I can't. I believe it's clear to her now that following court orders isn't a choice, but it's something that she absolutely has to do. She's prepared to do that. So we'd ask the court. She has stable housing now, and so I think complying with any conditions that the court sets to ensure both the safety of the public and the that she appear in court and comply with any of the court's orders will be much easier for her to accomplish. So we'd ask the court to maybe reinstate her previous bond and allow her to be released.
Any response from the people? Amen. So first of all, Gaines,
Yes,
counsel indicates to me that you now understand you have to follow the court's orders.
absolutely.
What happened the first time? Why didn't you?
Situations with my living and relationship I was in.
So if I were to release you, how do I know you're not going to just fall back into that and end up back here?
I'm not. I have a stable home now with family member.
That's different from where you were staying
Absolutely.
before.
Yes.
And I believe she would be local here in Ann Arbor, Judge, rather than.
You were on testing, right?
Yes. Well, that's fine. I mean,
No, were you on testing before you were released?
no.
Yeah, that's what I was wondering. What were you testing before? Were you testing?
No.
So you didn't have any alcohol monitoring?
No.
I'm not seeing anything in my life either, but the people at this site would be asking for alcohol testing.
Trying to figure out, we issued a no bond warrant. I'm not sure. There's another case, that's why. All right. I got it. September.
September 11th.
It was a while back.
Yeah, so
What did that indicate? She's on some. You were going to community corrections previously though, right?
Well, when I went to court the last time, they were saying that I had to but I never got released.
I have from my lovely coworker that she never made it to community corrections, so
She did. That's why she wasn't. Got it. Okay, that's why I don't see. All right. Okay, so I'll adjourn it to the 18th. Well, I'm going to change that. I'll adjourn it to the 25th. Previous bond is reinstated. I will indicate that there needs to be a scram tether prior.
Now, the courtroom gets complicated again. After discussing a bond change, the judge reviews the defendant's situation, testing history, and whether earlier conditions were actually completed. The result is a reminder that release decisions depend on verified compliance, not promises. When supervision breaks down, should another chance come with serious restrictions?
Prior to release.
Approach.
Sure. Okay. So no, it's okay. We'll get it together. With regard to the request for a change in her bond, I'm going to deny that request given the circumstances of this case. Her bond will continue. I will set this then for the 18th as originally set.
Thank you.
2026, 9 a.m. All right. Thank you. Court calls the case People versus Maurice Boyd.
People. I got on behalf of the board, we are both approach. Thank you.
Maurice Deshaun Boyd.
Thank you, sir.
Because we're asking for an adjournment.
You know what? Good, Mr. Boyd was coming up with her. That's NASA has moved that fast up voting.
What's moving fast?
Word.
Broke. Had to slow down.
Yeah, okay. All right. What do we do?
Judge, we want to look into some treatment court options for Mr. Boyd.
All right. Probable cause conference then will be adjourned to 25th, 2026, 9 8. All right. Thank you.
Thank you. God bless. Thank you.
There. Court does call the cases of the people versus Taiwan Griggs.
Well, to the people.
Michael Gaddy, Assistant Public Defender for Mr. Briggs, Your Honor. He's making his way into the courtroom.
On the 24 case. The order on competency?
Correct.
Okay.
The order of the finding.
The order on the findings. All right.
Your name? Taiwan Grace.
Thank you, sir.
Yeah, good morning.
All right. What are we doing?
Your Honor, I've submitted a green sheet. We're asking to adjourn this matter a couple of weeks so that we can continue discussions with the people. And Mr. Griggs does have a hold out of Garden City. There is a release to treatment order in these files signed by Your Honor. He's got a hold out of Garden City that he's hoping to clear up on June 15th via Zoom. I did check the Garden City Court's website. There is an arraignment scheduled that day. It's a resisting charge, Your Honor, a felony. I don't know what their bond will be set there. I was going to ask the court, we have spoken to Mr. Griggs' sister who reports he can't stay with her if he is released. I'd ask the court to consider if he is able to clear the warrant in Garden City to consider a personal bond.
I won't consider it this time until we see what happens in Garden City. You're requesting an adjournment. Is the 18th going to be enough time for you?
Yes, Judge.
All right. Now I'll adjourn these matters to June 18th, 2026, 9 a.m. On the 2000, Mr. Gaddy.
Yes, Judge.
You've requested of Ms. Gaines, but on the 2024 matter, a corrected order on the competency finding
Okay.
to the court. And we need that today if we can get it.
Yes, Your Honor. I will see if I can't get that corrected.
All right. Thank you.
24.
Yes. Is it possible to get a bond reduction? All right. Thank you. Thank you, Mr. Griggs. Court calls the case People versus Nicole Bragg.
Morning, Your Honor. Ashley Hannibal for Ms. Bragg. Requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Davi Lebo.
I thought you were Cannon.
Cannon's not here today.
That's why it's been so quiet. Okay. So just between us, who do you like better?
Tough call.
No, it is.
I might
Like
have
her.
to go with Miss Cannon. Yeah,
What did you say?
Cannon.
Really?
Yeah.
You got to learn. The lawyer should have answered whoever is in the room. Cannon's not here. You should have said Lebo. You're not? I'm offended for you. Huh? Like,
I don't think so.
okay. Permission to practice is granted.
All right, thank you. We have not been able to get in contact with Ms. Bragg, and we would like to adjourn.
You would?
Yes.
Who told you to do that? Spo?
Yes.
I see why you like it better. He was putting you up here. You're to get set up because I'm not doing that, right? All right. I would note that there is also your client has a bond violation and has not appeared at community corrections since release. So a bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety. That warrant will issue immediately. Thank you.
All right. Thank you, Your Honor.
Really shuts Cannon better. That's that. I don't know. I would have picked Lebo. That's on principle, really. Court calls the case of the People versus Seth Cope.
For the judge, court shall feast to first assistant public defender on behalf of Mr. Seth Cope, who should be approaching. When you arrive, Mr. Cope, please state your name for me.
Seth Cope.
Thank you. We are in the process of the work on a global resolution. I believe Mr. Cope has a few other matters pending. We'd be asking for a brief adjournment.
So how much he's got other cases, obviously.
Judge.
How much time are you gonna
3 weeks, I would think, Judge.
3?
Please.
Will work? All right.
Four font.
He has a case of the 22nd for UFP that was up yesterday and that bond denied, and the also case of working for talking with the same victim denied it up today.
Got it.
I was just.
All right. And you're trying to work it. Okay. Why don't I just do July 2nd, 2026, 9 a.m. See if it's all wrapped up.
Thank you.
Okay? Fine, we'll continue. Thank you.
Since last year.
Go change that.
Court calls case People versus Aaron Brandon.
Okay.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Brandon, making his way up to the podium, Judge.
Aaron Brandon.
Thank you.
We are asking for, some examine the next.
Oh, you're asking for
No,
what?
yes, Your Honor, we're asking.
Point of preliminary examination?
Yes, Judge.
Yes. All right. Discovery is complete.
To the best of my knowledge, Judge, I believe there's one already set. Is it next Tuesday? No, on a different matter, Judge. I'm sorry.
Okay. So he doesn't have another one set.
They're set for on a different cases of different victims. So these are two separate.
So he's got one set on the 9th or the 16th? 9th? Okay. But these are separate cases. All right. Then and so would the people have their witnesses ready in this on the 16th? All right. Preliminary examination will be set in person, 16th, 2026, 9 a.m. before me. Bond with its conditions will. Thank you. Court calls case People versus Ryan Miller.
As this courtroom session closes, the judge moves through cases involving examinations, adjournments, treatment options, bond conditions, and pending matters. One lesson stands out. Every delay or release carries consequences and expectations. Compliance can open doors, while violations can close them quickly. Like, comment, and subscribe for more courtroom stories.